I'm not an attorney. I do not have a license to practice law. I do not practice law. What I do is study law and tell people what I've learned, how I gather information. That being said, if you think you need legal advice, I would highly encourage you to hire a licensed and hopefully competent attorney and be legally advised. But in the event that you find yourself, much like myself, charged, or I should say, build out of being able to afford adequate representation and definitely not trusting the public defender's office, and not that they necessarily would have done a bad job, but this one, I didn't trust anybody anywhere, particularly within the jurisdiction, because of the principal parties in this case. One was at the time, and now retired, sitting judge, and as you can see, I was kind of confused as to what to do. There's a sitting judge and a City of Tampa police officer who was actually in charge of the mayor's security detail that were involved in this case. So one day, my business spirit universe told me, hey, you got a warrant for you. And I said, oh, I have a warrant. I haven't done anything. Lo and behold, I go and check and there's a warrant. And despite what some may believe, that's actually what happened. I checked for the warrant, called a bail bondsman who I know, and he thought it was just strange, and so I met him the next day because he said it probably wouldn't be smart to go that night. And I meet him there and I do the walkthrough. When I get there to do the walkthrough, the first thing I ask for is let me see the warrant, because I'm aware, as many people should be, and if not, then you can look it up and see whatever the protocol is in your state or the procedure in your state or local jurisdiction for issuing warrants, particularly felony warrants, which mine was a felony warrant. And they didn't show me the warrant. So I thought that was kind of strange. So I'm thinking to myself, I don't want to make too big of a deal about this inside of this walk-through jail situation. I go in, turn myself in, get printed, and leave. First thing I do is I file for discovery, and in the midst of discovery, I ask for the particulars as to what brought about this particular action. And I find out later on that there was an information file that spoke to my situation. So let me go ahead and go over a couple of these things as we do a little bit of housekeeping. Right here is what an information looks like. You see this, and here it is. Count one, me. They actually call me Greg, which is kind of interesting because that would mean that they are either familiar with my internet persona or something else that I was doing. But anyway, made a false statement which he did not believe to be true. To wit, he was indigent and did not own any real property under oath in an official proceeding regarding a material matter contrary to the form and statute and such, all this other blah, 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 blah. Anyway, charged me with perjury. Now, we can get into this in another video. Didn't happen. Not at all. And what's kind of interesting, since they said this, that I was indigent, didn't own any property, which was not a question on the indigency application, this was about properties that I had lawfully acquired from somebody through a quitclaim deed. That individual had purchased the properties through a clerk's auction. So the clerk sold him the property, gave him a certificate of sale, gave him a certificate of title. He decided, for whatever set of reasons, that he did not want to defend the houses against the banks. And I said, hey, sell the house to me. It's nobody's business. We come with an agreement. He sells the house to me via quitclaim deed. Successful quitclaim goes into the court record, and next thing you know, the house is transferred from his ownership, because he was the listed owner in the court records, over to me being the primary owner. What's kind of funny about this is they began to slowly take the houses out of my name without affording me adequate due process or the ability to defend the properties, because of the superior versus inferior lien issue. However, in none of these cases was there ever an evidentiary hearing. That's just some things for those who may be familiar with that, but we don't have to get too much into that right now. We can tackle that later on. As you see right here, here's a direct file capias, which was signed by, at the time, the